Good morning. Welcome to this live broadcast of the Senate morning sitting on this day of the 23rd of February 2022. This live broadcast is brought to you by the Parliamentary Broadcasting Unit in partnership with the Kenya Broadcasting Corporation. Lined up for debate on the floor of the Senate this Wednesday morning are a total of 9 bills, 7 of which will see the members proceed on a committee of the whole to debate and then get into division. These bills include the Heritage and Museums Bill, Senate Bills number 22 of 2021, tabled by Honorable Senator Dr. Alice Milgo, which would be a resumption of debate interrupted on Tuesday, 25th of January 2022. The County Oversight and Accountability Bill, Senate Bill number 17 of 2021, tabled by Honorable Senator Leda Molekina, is also scheduled to proceed to the Committee of the Whole, where members will go into division to see whether they will be adopting any amendments proposed to this particular bill, or they will be adopting it as it is. The County Government's Amendment Bill is also scheduled to go into division. It is a bill tabled by Honorable Senator Moses Kajwang. The resumption of this debate is this morning after it was interrupted on Wednesday, 22nd of December 2021 in the morning sitting. Also lined up for debate at the Committee of the Whole this morning is the Elections Amendment Bill, Senate Bills number 42 of 2021. This one is tabled by Honorable Senator Kipchumba Murkomen. Also, the Kenya Medical Supplies Authority Amendment Bill number 53 of 2021 by Honorable Senator Naomi Shionga will be discussed and debated and as well voted on in a committee of the whole this morning.
Honorable Senators, Madam Speaker,
Protection of Livelihood Bill, Senate Bill number 7 of 2021 by the Chairperson Standing Committee on Tourism, Trade and Industrialization will also be debated in the Committee of the Whole this morning. So those are some of the bills that will proceed on a Committee of the Whole. Honorable Rose Nyamunga, she will be overseeing this morning Senate sitting. I will now hand you over for the live broadcast. Good morning. My name is Kamche Menza.
let us pray. Almighty God, we beseech you to behold with your abundant favor and blessings as your servants whom you've been pleased to call to these leadership positions in this republic. We seek guidance to treat and consider all matters that shall come under our deliberation in so just and faithful a manner as to advance the peace, prosperity, and welfare of our country and of those whose interests you have committed to our charge. Amen.
Order number 1, administration of oath. Order number 2, communication from the chair. Order number 3, messages. Order number 4, petitions. Order number 5, papers.
Majority Leader, Senator Pukisho.
Madam Speaker, I beg to lay the following papers on the table of the Senate today, the 23rd of February, 2022. 1, report of the Auditor General on the financial statement of Nyeri County Elimu Fund for the year ended 30th June 2020. 2, report of the Auditor General on the financial statement of Gatanga Community Water Scheme for the year ended 30th June 2020. 3, report of the Auditor General on the financial statement of Taita Taveta County Emergency Fund for the year ended 30th June 2020. 4, report of the Auditor General on the financial statement of the County Assembly of Taita Taveta Car Loan Scheme for the year ended 30th June 2020. 5, report of the Auditor General on the financial statement of Taita Taveta County Datu Sawazisha Fund for the year ended 30th June 2020. 6, report of the Auditor General on the financial statement of the Madeira Water and Sanitation Company Limited for the year ended 30th June 2020. 7, report of the Auditor General on the financial statement of the County Assembly of Turkana Car and Mortgage Fund for the year ended 30th June 2020. 8, report of the Auditor General on the financial statement of Turkana County Biashara Fund for the year ended 30th June 2020. 9, report of the Auditor General on the financial statement of the Turkana County Education and Skills Development Fund for the year ended 30th June 2020. 10, report of the Auditor General on the financial statement of the Turkana County Emergency Fund for the year ended 30th June 2020. 11, report of the Auditor General on the financial statement of the Gatundu Water and Sanitation Company Limited for the year ended 30th June 2020. 12, report of the Auditor General on the financial statement of the Mukureini Water Services Company Limited for the year ended 30th June 2020. 13, report of the Auditor General on the financial statement of Kiambu County Alcoholic Drinks Control Fund for the year ended 30th June 2020. 14, report of the Auditor General on the financial statement of Laikipia County Emergency Fund for the year ended 30th June 2020. 15, report of the Auditor General on the financial statement of Limuru Water and Sewerage Company Limited for the year ended 30th June 2020. 16, report of the Auditor General on the financial statement of Muranga Fort Beverage Industries Company Limited for the year ended 30th June 2020. 17, report of the Auditor General of the financial statement of the Gatamadi Water and Sanitation Company Limited for the year ended 30th June 2020. 18, report of the Auditor General on the financial statement of Kisumu Water and Sanitation Company Limited for the year ended 30th June 2020. 19, report of the Auditor General on the financial statement of Kirinyaga Water and Sanitation Company Limited for the year ended 30th June 2020. 20, report of the Auditor General on the financial statement of Migori County Ward Development Fund for the year ended 30th June 2020. 21, report of the Auditor General on the financial statement of Migori County Assembly Car Loan and Mortgage Fund for the year ended 30th June 2020. 22, report of the Auditor General on the financial statement of Kericho County Bursary Fund for the year ended 30th June 2020. 23, report of the Auditor General on the financial statement of Embu County Education Support Fund for the year ended 30th June 2020. 24, report of the Auditor General on the financial statement of Baringo County Youth and Women Fund for the year ended 30th June 2016. 25, report of the Auditor General on the financial statement of Baringo County Youth and Women Fund for the year ended 30th June 2017. 26, report of the County of the Auditor General on the financial statement of Baringo County Youth and Women Fund for the year ended 30th June 2018. 27, report of the Auditor General on the financial statement of Baringo County Youth and Women Fund for the year ended 30th June 2019. 28, report of the Auditor General on the financial statement of Baringo County Emergency Fund for the year ended 30th June 2020. 29, report of the Auditor General on the financial statement of Kakamega County Dairy Development Corporation for the year ended 30th June 2019. 30, report of the Auditor General on the financial statement of Kakamega County Agricultural Inputs Fund for the year ended 30th June 2020, and 31, report of the Auditor General on the financial statement of Kilifi County Ward Scholarship Fund for the year ended 30th June 2019. I thank you, Madam Speaker.
Thank you, Senator. Next order.
Order number 6, notices of motion. Order number 7, statements.
Honorable Senators, okay, next order. So we are going to defer order number 8, number 9, number 10, and then we take order number 11.
Order number 11, Committee of the Whole, the Elections Amendment Bill, Senate Bills number 42 of 2021.
Honorable Senators, we are ready to do the Committee of the Whole. Where's the, I need the order paper. Honorable Senators, we are ready to do, we are on Committee of the Whole, Order number 11, the Elections Amendment Bill, Senate Bills number 42 of 2021 by Senator Kipchumba Murkomen.
Just hold it.
Honorable Senators, we are ready to proceed on the Elections Amendment Bill, Senate Bills number 42 of 2021. Senator Murkomen.
Clause 2.
Senator, wait a bit. I propose the question that clause 2 be part of the bill. Mover, Senator Murkomen.
Thank you, Madam Chair. Madam Chair, I would like to propose an amendment to clause 2, that clause 2 of the bill be deleted and substituted with the following new clause. As indicated in the order paper, but I'll read it for the record, Madam Chair, that Section 22 of the Election Act is amended by deleting subsection 1 and substituting therefore the following new subsection. A person is eligible for nomination as a candidate for an election under this Act if that person is qualified to be elected to that office under the Constitution and this Act, and B, holds a certificate, diploma, or other post-secondary school qualification acquired after undergoing a period of at least 3 months of study in a recognized institution, and in such manner as may be prescribed by the Commission, or C, has served as a member of Parliament or a member of County Assembly under the Constitution of Kenya, or as a councillor under the repealed Local Government Act. Madam Chair, a brief explanation of this is that if you look at the amendment that was in place, the original amendment was to the effect that I was proposing that to be elected to a member of Parliament and County Assembly, you should have the ability to read and write. But after the debate in the chambers and consultation with the committee and members of this House, it was, Madam Chair, proposed generally by many of the members that basic education is important, at least someone to have a Form 4 certificate and then a certificate on top of it, like it was before, in the law before the degree requirement was proposed. If you look at the people who have basic education in Kenya, it is a reasonable number. It's over half of the population. This one can be accommodated, unlike the situation where you say a degree with only 3.5% of the population having qualification of a degree. So for that reason, Madam Chair, and in consonance with what the members are proposing in the House here, I am proposing that the qualification be moved up to basic education, which is a Form 4 certificate or a secondary certificate if it was in the old system, and then you must have a certificate on top of it, which is at least acquired after undergoing at least a study of 3 months of study in a recognized institution. The other thing to be captured here is that if you look at that qualification of post-secondary with a certificate, a 3-month certificate, it is also important to capture that if a person has been a member of Parliament for 5 years, that qualification is automatically achieved if you look at it in terms of experience. So the experience that has been, relevant experience that have been captured in this law is the experience of having served at least for 5 years as a member of County Assembly, as a member of Parliament, or as a councillor in the local authority in the previous act. That gives you the leeway to be able, in lieu of the other education requirements, this becomes a necessary and relevant experience to be able to give you the gate pass to qualify to run. What many people don't appreciate is that this is not an appointive office. So there is no way you can say automatically, because you have the basic qualifications, you are automatically going to be an MP or an MCA. You still have to go through rigorous campaign processes that will ensure that you are elected. And therefore, Madam Chair, this is at least the minimum we can give to our people in the beginning. One thing Senator Sakaja captured, and as a member of the Legal Affairs Committee, is that in their study, they didn't find a country where academic qualification was necessary, except in Uganda, where O-level is necessary in Uganda. The rest of the countries in the world, nobody thought about academic qualifications as a necessary requirement. One of the reasons why people came up with this academic qualification was not actually because of the professional knowledge. No, it's about ability to speak English and Swahili, to be able to debate. And in the rest of the world, that is not a requirement. It's not a mandatory requirement. If you go to countries like South Africa, they have more than one national language. You don't have to debate in English to be able to speak in South Africa. You can use Afrikaans. You can use also Bantu language, any of the Bantu languages in the South Africa. If you go to Europe and US and all those countries, English is their mother tongue. So it's not speaking good English is not an achievement by itself, because you were born, brought up speaking English. The problem with us here is that we have glorified ability to speak in English to the extent that now it's forcing us to say you must have certain academic qualification. But if you look at the qualification in all those countries, if it's Spain, they speak in Spanish, so they don't have to worry about ability of their leader to communicate. If it's Italy, they speak in Italian. Yeah. So Kenya here, if we were appreciative enough of the situation we have as a country, speaking in Swahili is enough, and to communicate. But because of where we are moving, I think this minimum academic qualification should be the highest we should ever go, and allow the rest of the Kenyans to make determination. I asked them to say, Madam Chair, and for Kenyans to remember, today there is no degree requirement, for you to be a senator. But this chamber has 95% degree holders, and maybe even 50% postgraduate degrees in this chamber. Yet the qualification is just post-secondary. If you go to National Assembly, the same. 80 to 90% have degrees, but it's not written anywhere that you must have a degree. If you go to many of the county assemblies, you'll get at least 4 or 5 people, almost a third of the chamber having degrees. So it means Kenyans themselves, by their own choice, during voting, will say, no, this guy has relevant academic qualification. We educated this man. Let's vote for this one. But it should not be an opportunity for us to block others who would have served, Madam Chair, who do not have that very high level of qualification. And if there is nothing else that should convince anyone, is what the court said, that you cannot expect that 3.5% of Kenyans should the only ones enjoying the rights of political rights under Article 38 of the Constitution. I thank you, Madam Chair, and I beg to move. Is that how it is said?
Who is...
You don't have to second, Madam Chair, yeah.
I propose the question that clause 2 be amended as proposed. I put the question that clause 2 be amended as proposed. Division at the end.
The title and clause 1.
I propose the question that clause 1, the title and clause 1 be part of the bill. I put the question that the title and clause 1 be part of the bill. Division at the end.
We have not report progress because we cannot proceed.
We are now reporting progress. The mover, Senator Murkomen.
Honorable Chairperson, pursuant to Standing Order 148, I beg to move that the Committee of the Whole do report progress on consideration of election bill, Senate Bill number 42 of 2021, and seek to leave to sit again tomorrow. Why are we doing that?
I put the question.
Yeah, put the question.
I will put the question, which is that the Committee of the Whole do report progress on its consideration of the of Elections Amendment Bill, Senate Bills number 42 of 2021, and seek leave to sit again tomorrow. May as many as are of the opinion say aye. Aye. And those of the contrary opinion say nay. The ayes have it.
Number 16. It's a motion.
Now you come here.
Give me this tenant's bill. Okay, you have to call me.
Chairperson to make
Madam
to
Speaker,
make the report. To make the report.
Madam Speaker, on behalf of the chairperson, Honorable Speaker, on behalf of the chairperson, I beg to report progress that the Committee of the Whole has considered the Elections Amendment Bill, Senate Bill number 42 of 2021, and seek leave to sit again tomorrow.
Mover, Senator, Majority Leader.
This one. The mover. Honorable Speaker, I beg, on behalf of the mover, I beg to report progress that the Committee of the Whole has considered the Elections Amendment Bill, Senate Bills number 42 of 2021, and seeks leave to sit again tomorrow. No, that's the wrong one, right? Honorable Speaker, I beg to move that the House do agree with the committee in the said report, and ask Honorable Senator to second.
Senator.
Madam Speaker, I second.
Honorable Senators, I will propose the question, which is that the House do agree with the committee on the said report. Honorable Senators, I put the question, which is that the House do agree with the committee in the said report. May as many as are of the opinion say aye. Aye. And those of the contrary opinion say nay. The ayes have it. Next order. Honorable Senators, for the convenience of the House, we are going to skip order number 12, 13, 14, and 15. So we proceed to order number 16. Next order.
Order number 16, the Landlord and Tenant Bill, National Assembly Bills number 3 of 2021, second reading.
Senator Majority Leader, Senator Pogisho.
Madam Speaker, I beg to move that the Landlord and Tenant Bill, National Assembly Bills number 3 of 2021, be now read a second time. Madam Speaker, this is a very important bill. The bill was published on the 12th of February 2021, passed by the National Assembly, and referred to the Senate on the 21st December 2021. The bill seeks to introduce a legal framework which balances the interests of landlords and tenants in a free market economy by ensuring that landlords earn reasonable income from their investments in housing and also protects the tenant. Additionally, Madam Speaker, the bill consolidates the laws relating to the renting of businesses and residential premises and seeks to regulate the relationship between the landlord and the tenant. Currently, Madam Speaker, there are 3 main types of legislation that regulate the relationship between landlord and the tenant. They include the Rent Restriction Act, Chapter 296, the Distress for Rent Act, Chapter 293, Laws of Kenya, and the Landlord and Tenant Shops, Hotels, Hotel and Catering Establishment Act, Chapter 301 of the Laws of Kenya. But Speaker, tenant and landlord disputes are inevitable. Despite the most mutually beneficial relationship between them, disagreements arise for various reasons. In most cases, these disputes have to do with tenant rights, responsibilities to repair rent, eviction, and several other conflicts. For this reason, this bill seeks to introduce some far-reaching provisions that address the interests of both the landlord and the tenant. For instance, the bill makes a provision to allow rent to be determined by mutual agreement. Where there is no mutual agreement, a tribunal on application by either party will determine the rent based on the comparable premises within an area. Madam Speaker, this bill applies to all residential premises, except a few exceptions, Madam Speaker. Accepted residential premises, 2 residential premises leased on a serviced tenancies, i.e. premises let to an employer who provides the premises to an employee in connection with their employment. And 3, residential premises whose monthly rent does not exceed such amounts as prescribed by the Cabinet Secretary. So those are the exceptions, Madam Speaker. Madam Speaker, a tenancy of a business premise which is not reduced in writing, and 2, reduced in writing, but for a period not exceeding 5 years, and contains a provision for termination other than breach of a covenant within 5 years of the commencement of the tenancy term. Madam Speaker, specifically the bill proposes the following, and just take a few. In Part 2, the bill provides for the establishment, composition, and jurisdiction of the landlord and tenant tribunals. It specifies the powers of a tribunal and provides for the staff and expenses of a tribunal. B, which is Part 3, the bill provides for the administration of a tribunal. The bill specifies the functions of the chairpersons, the deputy chairperson, and the secretary for a tribunal. This section also provides for the removal of a member of a tribunal and the investigation of complaints by a tribunal. Part 4 of the bill provides for general matters relating to tenancies, including fair rent, permitted increase of rent, notice of termination, and the right to assign or sublet rent or premises. The part also provides for alteration of terms and conditions in the tenancy, reference to a tribunal and the decision of a tribunal. It further provides for keeping a statement of rent paid, the keeping of a record of payment of rent, and the condition of statutory tenancy. Part 5 of the bill deals with eviction orders. The bill provides for the power of a tribunal in matters relating to eviction. Madam Speaker, the Part 6 contains miscellaneous provisions. It contains the service of documents, enforcement of orders, prosecution of offenses, distress for rent, disposal of property by a landlord upon death or abandonment of the premises by tenant, and the power to make rules and regulations. F, the schedule specifies terms and conditions to be implied in tenancies. Madam Speaker, notably, this is an important bill which makes and takes some preemptive steps to avoid problems arising between landlords and tenants. Its good intentions of reinforcing and safeguarding the rights of the two parties. And already, Madam Speaker, has passed the National Assembly. It is for me to plead and ask the Senate to go ahead and support and pass it so that we'll have better relationship between our landlords and tenants. There are many problems right now, Madam Speaker, that I think has been straightened by this bill. If you look, Madam Speaker, at the sections that deal with that, I just do an example about subletting. There are people who can take your property and sublet it, and then, of course, there's a lot of disuse of these properties, and then you get into conflict with people who are not primarily the primary tenants, and this bill wants to deal with that. Madam Speaker, I think it's a straightforward bill. I would like to, therefore, appeal or ask my colleagues to support it, and with these remarks, I beg to move and request Senator Murkomen to second. Thank you, Madam Speaker.
Senator Murkomen.
No, I don't mind. I'm just saying. Madam Chair, I thank you for the opportunity and thank the Majority Leader for ambushing me to second this very important bill. This bill is very important. For those who understand the management and the practice of landlord and tenants, first of all, you know that in the legal regime regulating this sector at the moment is fragmented. And Madam Chair, we have 3 bills, 3 laws that regulate this sector at the moment. You have the Distress for Rent Act, then you have Rent Restrictions Act, and you have Landlord and Tenants, which deals with shops, hotels, and catering establishments Act. These 3 laws are the ones that are regulating the relationship between landlords and tenants. The first responsibility of this bill is to create one regime of law to ensure that all these, to amalgamate all the provisions of these 3 laws and have one legislation that is governing this relationship. Number 2, Madam Chair, the law recognizes that the relationship between a tenant and landlord is imbalanced in the sense that one of them, Madam Chair, is the property owner, the other is leasing or renting that property. And Madam Chair, that relationship can adversely affect not just the tenant, but the people who are beneficiaries of the tenant. Now, in cases of family, you have a family member who has rented a premise, but you have children who are depending on that family. And so the issues here is that the law practically appreciates that relationship, that money is not available all the time. But at the same time, that the landlord has a responsibility to continue receiving rent. And so in some cases, Madam Chair, that rent is received as a result, that the money that's received as rent goes to a loan that developed that property. So there is that recognition and therefore protection. But also to know that the social fabric of the country depends on having citizens who have who are living in humble abode, or basically having achieved Article 43 right to housing. This law also has something to do with Article 43, the right to housing. That is that, yes, once you have housed someone, has rented your premises, there are certain expectations from that person, but the landlord also expected to do certain things. Madam Chair, it also recognizes that disputes can arise as a result of this relationship. And so the first provision, first of all, Section 3 of the Act is providing circumstances under which the law applies. It deals with situations that is dealing with residential premises. And the law recognizes that there is an exemption of certain residential premises by the order of the minister. There is also a residential premises let on service tenancies and residential premises whose monthly rent exceed that which has been said by the Cabinet Secretary. That relationship is not regulated here. The most important thing to know about this bill is, first of all, to realize that it's protecting small people, okay, who are renting premises from being harassed by the landlord, but also protecting the landlord to ensure that they get their right. That is the imbalance they deal with. And this includes also, again, tenancy for business premises and so forth. Madam Chair, this law establishes a tribunal to deal with these disputes that may arise. And so in Section 4, there is establishment of landlord and tenant tribunal, whose jurisdiction is to ensure within the territory of Kenya, and has a lot of responsibilities to give orders. If you look at the tribunal, first of all, I think there is an oversight in the law itself, and Majority Leader in the committee stage, Section 4 needs to be amended accordingly, because it only recognizes the chairperson, the deputy chairperson of the tribunal. It doesn't state that, unless I have skipped something, it doesn't state that how many other members of the tribunal and their qualifications. That has to be sought. But I am glad that the bill recognizes that the tribunal, the chair must have the qualification of being a judge, and the vice chair be a person who has practiced law for more than 5 years. And then the responsibilities of the tribunal are listed. What is notable in this is that in this law is that the tribunal has a responsibility to make a decision within 3 months, because also it recognizes that you cannot use mechanism for delay to deny a particular member right to continue collecting rent from his premises. It also gives the powers the tribunal to issue orders of injunction, grant injunction to a member who may want to get orders to stop eviction from a premise. This is a very, very progressive provisions of the law. There is provisions of how to appoint, how to administer the tribunal, the roles of the chair, the roles of the vice chair, how to remove a member from the tribunal. There is general provisions related to what is a permitted increase of rent. You know, so you can't just wake up and tell a tenant, tomorrow you pay this much. First, there is permitted increase as required. And the law says that a landlord shall not increase the rent payable by a tenant for rented premises unless the landlord gives the tenant at least 90 days written notice of intention to do so. That gives you enough time to say, I no longer want to live in this premise, I can move to another premise. So you cannot just wake up and say, tomorrow the rent has moved from 5,000 to 10,000. You must give the necessary notice. And the law now requires a notice of at least 3 months. And that intention will have the landlord's intention, amount to be increased, and any increase that as established by the law that is going to be given without the express, without a 3 months notice is declared void. And that's where now the tenant can resort to the tribunal to be able to get the necessary orders. The landlord also may increase rent in accordance with this section if the landlord has has carried out the necessary, capital investment in the property, provide new services. Sometimes that's the reason why you increase. Maybe security has been increased, CCTV cameras have been installed, or perhaps there is an increase of supply of services. You have water, you have security, which was being paid by the members themselves. Maybe security has been increased. But those are some of the grounds that may lead to increase of the rent. Of course, most of the increases are usually linked to the cost of living. If the cost of living becomes high, the landlord is forced to do so. There is also, the law provides for notice of termination, which is that the landlord or a tenant may give notice to terminate the tenancy agreement. And you must be clear about which premises, the date which the tenancy will terminate, and it must be at least 2 months in case of residential premises and 3 months in case of business premises. Again, you must give 2 or 3 months. Must be signed, and it must be presented in person or through the agent. There is other limitation to increase of rent that's provided by the law. The Section 20 says that a landlord who is lawfully entitled to increase the rent charged to a tenant for premises may do so only if at least 12 months in the case of residential premises and 24 months in the case of business premises have elapsed since the date of the last rent increase of that tenant in the rental premises, and the premises were first rented to the tenant. So there is limitation also of period within which you can increase. If it is residential, you can't increase within the first 12 months since that person has leased the property. And if it's business premises, at least there must be guarantee of 2 years of payment of that rent. Thereafter, you now give 2 months notice and 3 months notice respectively. But the first 12 months, there must be guaranteed that it's only this much you can pay. Madam Speaker, let me just give a story here that, of course, this is the law, but sometimes can be varied by the parties themselves. In the case of High Trees, a 1945 case, High Court case in London, which was before Lord Denning, there was a crisis in UK at that point in time because of the Second World War, and people were unable to pay rent. So the landlord gave an undertaking to the tenant and told them, I don't want you to leave these premises. I think the company was called High Trees. So he told them, I don't want you to leave the premises. You can stay. You don't have to pay this rent until the economy improves because of the effects of the Second World War. When the economy improved, because it was not written, it was just an undertaking, and there was no consideration on the part of the tenant. So in law, for a contract to become viable, or for a contract to be called a contract, there must be an offer, acceptance, but there must be something called consideration. So consideration may be monetary in nature. So the landlord had given this undertaking that he's not going to ask for this rent. So in that case, after the period, the owner of the property went back to the tenants and told them, I want you to pay now. Since the economy has improved, you pay for the period that you had lived in these premises and never paid anything. And so the case proceeded, and when it went before Lord Denning is when he came up with a principle called the promissory estoppel, which says that if a person gives a promise to another, even though there is no consideration, and I rely on that promise, and I change my situation because of that, in this case, continue living in the premises, no consideration given, then the law says it is now an established common law principle that you are stopped from going back on your word because I have relied on that promise. That is how the promissory estoppel principle was established. I was just digressing to say, Madam Chair, issues of tenants and landlord and the promises that they give each other goes way to the beginning of 18th century there on, and has been developed over time. Now it's being concretized in law so that the tenants and the landlords cannot depend on common law principles but must go by the statutory provisions that we have given here. And you can see why, if you look at the law here, it's very detailed, because this is a relationship that has been there for over 300 years in the world, and has, about landlords and tenants, and it's been something that has been, a lot of experience has been gained over time. And that's why you see here, notice is very important. What is that notice entailing, and what rent provisions are we waiving, and what is it, how is it going to be presented, must be in writing. It cannot be, Madam Chair, a promise like the case of High Trees where the promise was verbal. Again, the law provides for grounds on which landlord may seek to terminate the tenancy. And there are many, many grounds here that says that a landlord have served a notice of termination of tenancy on the tenant. The grounds on which the landlord seeks to terminate tenancy may be as stated in the notice. And Madam Chair, there is provisions of, Madam Speaker, there is a provisions here of what is the limit of that notice, so that you don't also wake up and say, I don't like his face. Or you wake up and say, we don't want the Indians in this building. Or we don't want Maasais living in these premises. So therefore, as I've seen some of our colleagues campaigning in their county saying they don't like the people of this tribe, this community and all that. Those are grounds unaccepted in the Constitution. In the same way, there must be limits as to why, if I'm meeting all the conditions of tenancy, it will be discriminatory for you to just wake up and say, this is my property, you must go. This property also exists in public good, and it's regulated by the public, and it is protected by the state, which is members of public, for a particular common good. And therefore, there must be grounds with which a landlord can seek to terminate a tenancy. But if I am meeting all the conditions, then there is no reason why the tenant should be, the landlord should terminate. Those grounds are obvious. One is failure to pay rent for a period of 1 month, and you have persistently delayed in paying rent, which has become due payable, where under the tenants, under which the tenant also, of the time being, the tenant has any obligation in respect of the repair and maintenance of the premises comprised in such tenancy. If this agreement says you must do certain repairs, and I come to the premises and you have kicked everything, Madam Chair, the toilets are finished, the sinks, the doors, everything is, in disarray. It can be grounds of termination of tenancy. That the tenant has committed other substantial breaches of obligation, which are related to management of the premises. Maybe, Madam Chair, you have done some things. You've turned the premise, apart from just being residential, now it's a place where you are having disco, making a lot of noise to the neighbors. The other tenants are complaining about you. All these provisions are here. When you sublet, Madam Chair, if you go to all those county council properties in Eastlands, of course you will find that a house which was expecting one person to live, there is a Mabati extension behind there and has been sublet to somebody else, Some people rent premises and then they sublet to another person to carry out business, and it's common. And if the tenant is not aware of the same, or is not part of the tenancy agreement to sublet, then it can be a basis. It can also be terminated by the landlord if he wants to demolish, if the landlord wants to demolish and reconstruct the building and so forth, or by operation of law. That is where perhaps there is a new law, or government policy has changed, or has been acquired by the state for purpose of construction of a road, railway, whatever it can be happening. So again, the tenancy can be terminated by operation by such acts. There is a notice, the specific notice for demolition and repairs, and other, and so forth. The tenant also may, with the consent of the landlord, assign premises to another person. Again, if there is a consent of the landlord, but there are restrictions that are given by law under Section 30 that you must meet the conditions set by the landlord and so forth, and if the tenancy agreement has not been revised to deal with it. Again, the law deals with subletting, how you can be able to be allowed to sublet, and then application to tribunal to deal with subletting, and then it captures also all the issues related to recovery of sums of rent, how you go about it, recovering attachment of property, attachment of your salary, and of course processes that require that the tribunal is involved. Then you have eviction orders. There is also the law captures in Part 5 how to come up with an eviction order, and a notice that is given for eviction in the law itself, and the other procedural miscellaneous provisions, including the role of the cabinet secretary with the approval of the parliament exempt certain categories of premises that may not operate in the Act. I just want to hasten to say, Madam Chair, that a few amendments will be required. One, membership of the tribunal, Madam Speaker. Two, the role of county government. If you look at the cabinet secretary has been given responsibility here to establish which premises can be exempted and which one cannot. These regulations, the exemptions here, are said with the approval of National Assembly. Majority Leader, I think in the committee stage, and I'm sure the committee will look at it, this approval should be with Parliament, just like all other miscellaneous regulations. Subsidiary law should come to both houses of Parliament. Remember that relationship between landlords and tenants are highly regulated or dealt with at the local level. There is a role played by the county governments insofar as this relationship is concerned, collection of taxes, things to do with the licensing of these properties, and designation of where is residential and where is a business premise. All this should be involve county government. The best way to involve county government is to involve this Senate, is the role of this Senate insofar as ensuring that the role of the cabinet secretary is checked by Parliament. So it shouldn't be just National Assembly, should be Parliament itself, both houses of Parliament. Madam Speaker, I beg to second.
Honourable Senators, I now propose the question that the Landlord and Tenant Bill, National Assembly Bills number 3 of 2021 be now read a second time. Senator Olekina Ledama.
Madam Speaker, I thank you. Let me begin by saying that I rise to support the Landlord and Tenancy Bill 2021, a National Assembly Bill number 3 of 2021, and state clearly that it is quite timely. But as I read through the bill, I find that there are very, very important things that have been omitted. I have skimmed very fast through the bill, and I've looked at the way the bill has been drafted, and it is mostly to protect landlords. You know, in most cases, Madam Speaker, in all developed countries, there are legislations which are developed to ensure that even the tenants themselves understand their rights. In this bill, Madam Speaker, the tenant's rights are not clearly defined. One of the things which I find a bit contradictory in the bill, which I'd like to point out directly, begins with the issues of the tenancy agreement. It states very clearly, if you look at section 17, it says that these are the general provisions relating to the tenancies. It says that the rent payable for any premises shall be determined by mutual agreement of the parties to a tenancy agreement. Then the second clause contradicts the first statement, where it says, 17.2, it says, where an agreement cannot be reached by the parties at any time during the tenancy, the tribunal, on reference to either of the parties, shall determine the rent payable for the premise based on comparable or similar lettings. Madam Speaker, my concern with that second clause is that if the rent payable is supposed to be of mutual agreement, where do we then say, no, if we cannot agree on the rent payable, we go to a tribunal for the tribunal to tell us? That is actually saying that we have such a big shortage of properties that a tenant can be able to rent in this country, that they have to rent that. So because they are not in agreement, they will now force the owner, the landlord, to be able to go to the tribunal for the tribunal to determine how much should be paid. I find that a bit contradictory. And I would actually request the majority leader who has moved this bill to consider removing that clause or amending that clause to make it very simple, that where there is a mutual agreement, this is a covenant. It is between two parties. You don't want to antagonize any of the parties by bringing a provision that says, now, a third party who has got no interest in that building. Remember, I spent a lot of money to construct that building. I decided that I'm going to pay X amount of rent, to charge X amount of rent. If you are the tenant and are looking to come and stay in my building, you should come to my building. We agree together on how much should be paid, but not refer back to the tribunal for the tribunal to determine and say, we'll take a sample of the area and force you, the landlord, who instead of putting a tile that cost 300 shillings per square meter, you put one that cost about 10,000 shillings per square meter, but you are now forced to pay or to charge what the neighbor who only used the tiles for 300 shillings is charging. So I don't think that is fair to either the landlord or the tenant. So I would be seeking an amendment, and I hope that the majority leader can look into that and consider making those changes. Number two, Madam Speaker, if you look at section 18 of the bill, it states as follows. A landlord shall not increase the rent payable by the tenant or rented premises unless the landlord gives the tenant at least 90 days written notice of the intention to do so. We go back to the initial covenant. If you want to rent my premise, we agree that it's for a period of time, 3 years, and within those 3 years, I'm going to charge you X amount of shillings. So I've got no business increasing that rent within the first 3 years, Madam Speaker. Those 3 years, it will be sealed. So if I intend to renew the lease agreement, then at that point of time, we can now discuss whether I'm going to increase the rent or reduce the rent. So, Madam Speaker, I think this section 18 also needs to be amended, because it says, number two, if you read 18.2, it further continues and says, the notice to be given under subsection 1 shall be in the prescribed form and shall specify the landlord intention to increase the rent and the amount of the new rent. That will only be necessary if the covenant period or the time that you've agreed that I'm going to reside in that property has lapsed. But in the event that it's within the period of the covenant, it is not necessary. So I don't think we should over-legislate or make it difficult or create room for landlords to find ways to be able to exploit tenants. You know, with the kind of lifestyle, or rather the living conditions in this country now, where things are very expensive, people, middle class, or anyone, even us as legislators who are working, you would not get an increase in your salary. So if you say, I'm going to be staying here for 3 years, I have a contract with my company for 3 years, this is how much I should pay, and it will be able to help me survive, that should be the case. So that section 18 also needs to be relooked. In fact, if you look at the entire Part 4 does not take into consideration the interests of a tenant. It only looks at the interest of the landlords. Let me proceed further, Madam Speaker, and reiterate on one other very important issue relating to the tenancy agreement. Every time there is a tenancy agreement, there is always a deposit which is paid. This deposit, most landlords in this country, look forward to getting this deposit so that they can go and spend on their own issues. I think it is now time for us, and it behooves us as legislators, to be able to look at what happens around the world in terms of protecting that deposit. In countries like the US, where I lived for so many years, there is normally laws that governs the tenancy deposit. And there are two areas where you're supposed to protect that tenancy deposit. One, it can either be a custodial or an interest-based tenancy deposit security, where the landlord is supposed to protect that deposit in a government-backed deposit scheme, where if it's a government-backed deposit scheme, if you decide to make it custodial, they earn the interest, it pays them to be able to protect that deposit. If it is an insured scheme, then the agreement between the tenant and the landlord must clearly specify how that interest is going to be utilized or how it's going to be shared. Is it going to be 100% taken by the landlord, that money does not belong to him or her? Or is it going to be taken by the tenant who has decided to put that money aside so that it can protect in the event that there is something needs to be fixed in that house? Madam Speaker, I would have also hoped that this tenancy agreement would either think of a situation where it creates an escrow account. I know in terms of escrow, mostly it relates to mortgage schemes, but in this particular one, where in this country, KRA now requires a certain amount of money to be paid by the landlord as a tenancy income in taxes. So I think it will be important for us to amend this legislation and factor in all those issues of the escrow. Because if it was a tenancy agreement and you don't have to pay any taxes to KRA, then the escrow issue would not come into play. But today, I'm aware that even in our own offices, Senate offices, which are spread across the country, KRA requires us to withhold 15% taxes on the rent that we pay to our landlords. In the event that that money is withheld, KRA assumes that everybody is a tax agent. So long as you're collecting any money, you automatically becomes a tax agent, whether you have signed an agreement with KRA or not. So I think it is time for us now, when we are drafting legislation, to consider taking into consideration all these issues that will come in to dictate how the tenancy agreement should be run. So I'll be seeking either the majority leader or the committee stage amendment, or if they don't, then I'll be bringing the amendments. One, to define how the tenancy deposit will be handled during the period of the deposit, whether it will be a custodial account, or rather the government protected scheme, or whether it will be an insured account. And the tenants needs to know their rights. They need to be able to understand their rights. There's one thing that makes me happy here, and I think all landlords ought to be alive to this fact that you cannot just evict a Kenyan living in your property without the consent of the tribunal in the event that that tenant has not paid rent. Maybe he has not paid for 1 month, or has got a tendency of delaying in paying rent. Then you need to report that person to the tribunal. That is an issue that has been brought up by this bill. Then you get a consent from the tribunal for you to be able to evict that person. It is also very important to note that in this bill, it talks about a duration where if the eviction is not carried out within a stipulated period of time, I think it is 60 days, then it lapses. That person continues staying in that house. It can be extended if the landlord goes back to the tribunal and seek for an extension. But these are issues that the tenants and the landlords must remember, must be alive to. And I would really request that as part of the tenancy agreement, the piece of legislation that deals with this, like this, the landlord and tenancy, if it becomes an act, should be attached to the tenancy agreement, so that when, or maybe it should be cited in the terms and conditions for rental, so that the tenant and the landlord are well aware of their rights. Madam Speaker, the other issue that I'd like to communicate on this matter has to do with Section 30. This is also another issue of subletting. The law, as it's proposed, states as follows. A tenant may, with the consent of the landlord, assign premises to another person. It further continues and says, a tenant may give the landlord notice to terminate within 30 days after the date of the request made under subsection 1, if the tenant requests of the landlord to consent to an assignment of the premises and the landlord refuses to consent. Madam Speaker, these are things that we need not to over-legislate. These are things which need to be clearly defined during the time of signing the agreement. The agreement should be very clear that in my premise as a landlord, I do not agree, I do not approve any subletting. Then you as a tenant have a right to say, since you do not want me to sublet, then I'm not interested in renting your property. I think when you now give room to, in Section 30, Madam Speaker, when you give room in Section 30 to say that you now go and seek approval from the landlord, and if he refuses, then you can then choose to leave the property, then you will be negating all the other terms and conditions that you agreed upon. So I think to protect both the landlord and the tenant, the agreements must be clear from the onset that in this property, there's no subletting allowed. In this property, you can sublet, just notify us, but the terms and conditions continue being the same as the initial tenancy agreement. Madam Speaker, to conclude this, let me reiterate on the two issues that I raised. One has to do with the issue of how you secure the deposits. There are properties here and where tenants are required to pay about 6 months deposit, 3 months, about 6 months deposit before they can occupy the premises. It could be about 6 million shillings. That is a lot of money. If that money is not protected, either one to be safeguarded in either a custodial or an interest-bearing account, then there are chances that by the time when the tenancy agreement comes to an end, there'll be a big Mickey Mouse sort of like competition between the landlord and the tenant when the tenant wants to leave and get their deposit. We know, we've heard of so many stories where tenants do not get their deposit, or landlords make it very difficult to release the deposit paid by the tenants. I think the tribunal, instead of the tribunal just being, in every bill you give them so much power, I think the powers that you should give them is the powers to be able to determine whether the premises or whether the tenants knew the terms and conditions of them leasing the house or leasing a property. Number two, to finalize, it is the issue of the rights of tenants. Tenants need to know that they can live anywhere they choose to live in this country, and that when they are in that house, the period that they have occupied that period, since they're paying for them to be in that house, it is assumed they should enjoy all the rights that any Kenyans can enjoy in their own private place. This business of landlords entering into the premises as they choose must also come to an end. They can only do that if they notify, and maybe this is an amendment we should put in, if they notify the tribunal that there is a challenge with that tenant, and they seek approval for them to be able to enter the premises. The premises ceases to become 100% owned by the tenant, by the landlord, because there's a person who lives there who is paying for it. Otherwise, Madam Speaker, I fully support, and I hope that the majority leader who moved this bill has taken note of the areas of concerns, and they can be able to bring in some amendments to make it very clear. I thank you, Madam Speaker.
Thank you, Senator. Senator Cherargei Samson Kiprotich.
Thank you, Madam Speaker, for this opportunity. This is a very important bill, the National Assembly Bill number 3 of 2021, the Landlord and Tenant Bill. I think some of us who own property or rentals, and also Kenyans who live on our property, we need the protection of the law. And I hope as the majority leader works very hard, Madam Speaker, to ensure that there is expeditious handling of the National Assembly bills that originate from there, I wish the same could be replicated at the National Assembly whenever we have bills that originate from the Senate. And that has been our contention since we moved to court the other time. So I really want and hope that the majority leader will ensure also the way we are prioritizing and giving adequate and really high-level wisdom like of Senator Ledama on the matters that before the House. And then the National Assembly also must give adequate attention to our bill so that we complement each other. I think, Madam Speaker, a few comments about this is a straightforward bill. These are things that has been done in terms of tenancy, tenants and landlords. It's just we are establishing a legal framework that will guide and ensure that there is protection of the law. Because most of the people who own rental properties, residential homes, and many other places, and now we have ownership of sectional properties where there are sharing of clubs, swimming pools, stairs, or there's open spaces within apartments in the city and other towns within the country, Madam Speaker. This just guides and gives appropriate, and most of this should be done in good faith, because at the end of the day, if you are the landlord and there is a tenant, then the engagement of tenancy agreement should always be done in good faith. Madam Speaker, there is the issue of rent increment and the issue of reduction of rent increment. I think this became a challenge, Madam Speaker, especially during the COVID period. And we saw a number of Kenyans lose their jobs, and some of them could not sustain to pay rent. And some of the unscrupulous landlords went ahead to increase rent. It is good now that the law has provided that at least 90 days, or 90 days, that is around 3 months, that when a landlord has an intention of increasing residential property and other forms of property, that you give adequate notice. And I think that is very important, because one interesting thing in this country is that, and I saw it somewhere with the issue of increase in food prices, is that people, the income will remain constant, be it salary, but the expenses will keep going up. So you can imagine if somebody was paying 10,000 shillings for a property or a residential home or where they live, and there may be salaries around 30,000. But now that there is caveat or an opportunity of 3 months, Madam Speaker, it can give a new opportunity to that person to relocate so that they can look for a better housing, a better place where they can afford. So I think this stopgap measure is very important, because sometimes when landlords want to frustrate you, they can wake up one day, especially landlords in our small towns in the villages, they wake up one day and say your house is no longer 1,500, we need you now to pay 2,500. You can imagine the horror that such a family needs to adjust with hard economic times. And even the reduction, we saw a number of landlords, Madam Speaker, decrease those of goodwill, especially during the pandemic across the world, especially in Kenya. And I think some of the landlords, because of the challenges that some of them even gave rent-free months, others ensured, Madam Speaker, that there was a decrease, and many other factors that contributed, especially during the pandemic. And Madam Speaker, I think it is very important that, and I like the way the wording is. A landlord shall decrease the rent charged to, and that is clause 21, the tenant if the landlord ceases to provide any prescribed service with respect to the tenant's occupants of the rental premises. You know, Madam Speaker, landlords are very good people. When you are moving to their houses, they will tell you, we will be now mowing your grass, we will be working on the cutting, ensuring they take care of weeding their flowers, ensuring that they wash your cabros. They will ensure that we provide you security, the watchman at the gate will be collecting garbage. But after some time, when they are now comfortable, you have taken your money, you have paid deposit, you have paid, you have maybe rent for maybe 2-3 months. But I'm Speaker, the landlord disappears. So it becomes a challenge. And I think it is very important because maybe even the payment of electricity bills and water. So sometimes before you know it, when you are misled, in short, there was a misrepresentation because the landlord was excited and wanted you to rent their property, and then they promise you heaven. But they can't deliver by saying, we'll cut your grass, we'll ensure the trimming of the fence, weeding of flowers, cleaning maybe of the cabros, providing security services, payment of electricity bills and water bills that will be factored. So when you are paying your rent, you know the service that will be provided. Apart from the rental, there will be other additional services that will be provided. So I think, and also, Madam Speaker, when you move in, they can say they want to come and paint your house. Maybe by the time you move in, because maybe urgency, you move to the property, and they tell you maybe in 1 month time, I will send a painter to come or fix a few fixtures within the house, but they have not done it. And I think it is very important that that one has been noted. That is clause 21. But as Speaker of the powers and appointment of tribunal, I think those are procedural issues, and there is nothing much I can add. And even the powers that tribunal has, they have always had, and this has assisted, and especially in providing for litigation. Madam Speaker, another clause 27, a landlord may by notice terminate tenancy if the landlord in good faith requires possession of premises for occupation. And I think the date for termination, if the landlord, the spouse of the landlord, a child or parent of the landlord, which is okay, the date shall be at least 60 days. I think it would remain at 90 days, 3 months, so that you don't wake up, Madam Speaker, and you know the inconvenience of moving to a new house. Maybe where you live and where you work, there was proximity. But now, if you give only 2 months' notice, I think it is the better majority leader. Let's maintain at 90 days or 3 months, so that, Madam Speaker, it is also convenient. You can imagine landlord wants the house maybe for the child of the spouse, which is okay. But I think the timeline, Madam Speaker, should be 90 days. I think 3 months is more than sufficient to allow even you, maybe where you live, and where you need to relocate your children, the proximity to school, maybe to other public facilities, to your workplace was very convenient. But you will need, Madam Speaker, an adequate time, so that even if you have to move your children to another school, or even if you know, it was more proximate to the church, Madam Speaker, or a mosque. And you know, if you go far from the mosque or the church, your prayers might take long to reach heaven. So you will need to relocate, Madam Speaker, to where your spiritual nourishment, access to utilities like supermarkets and many other schools, and the mosque or the church, Madam Speaker. Clause 28, a landlord may give notice of termination of tenancy if requires possession of the premises in order to demolish. And I think this has been the biggest problem, Madam Speaker. We have found, and that is where creation of infrastructure, Madam Speaker, which are called, you know, we have forest evictees, we have internally displaced people. But nowadays, the biggest menace in this republic, Madam Speaker, especially in this city, is what we call infrastructural evictees, where either they want to demolish the premises that you are using or residential you are using to expand the roads. But how they do it, Madam Speaker, it is unfortunate. You wake up one day, especially in our cities, houses have been demolished, homes have been demolished without the due regard of the law. And I think that is where the growth of infrastructural evictees, in fact, the threat to this country, Madam Speaker, is no longer the forest evictees or even political or IDPs, Madam Speaker. The biggest menace in this country is infrastructural evictees. And I think it is very important that, Madam Speaker, it is unfair When you wake up one day, you find people, it is good to build roads. It is good to build public utilities. It is very important to build hospitals. But also you must be fair and have due regard to the law. And therefore, Madam Speaker, at least 120 days, which is, I think 4 months is sufficient. So that we, unless somebody has grabbed the land and there is an issue, then they can demolish at night. I think as a country, Madam Speaker, we need to move away from this. And I think 120 or 4 months is very important so that we prevent the creation of infrastructural evictees. You remember during COVID, there were people that were being evicted in Ruai, among other areas, even outside the city, Madam Speaker. And therefore, I really want, another aspect that has become a challenge, especially to hustlers, is, Madam Speaker, is the payment of goodwill payment. I don't know where that thing emanated from, especially in business premises. You go to Kisumu town, you go to Kisumu city, it's not a town. You go to Eldoret City, Nairobi, and many other big towns. People are paying goodwill payments, Madam Speaker. Oh, yes, oh, okay. So, Madam Speaker, so what we are saying is that you can find somebody, a young person, maybe have taken money, maybe youth fund. You want to rent somewhere in around the city. Maybe the rent for that small space within the city or the CBD is maybe 50,000 or 40,000. But the person who is inside there tells you, pay me goodwill of 2 million. I think this is what the majority leader needs to look at, because most young people cannot do business because of only one issue, what we call goodwill payment. And it is an issue that must be addressed once and for all, because I know many people who are business people, Madam Speaker, and mostly young people. I don't know where this culture of payment of goodwill came from. It is in millions, Madam Speaker. I had a friend who wanted to get a property, to lease a property, not even to buy, lease a property to do business within Eldoret town, and he was being told to pay 6 million. So I was wondering, how can 6 million, and these are startups, Madam Speaker, these are startups, businesses that we need to do. So the issue of, I think this will assist us in stopping unorganized or illegal demolitions, violation of many other property, Madam Speaker, and many others. Madam Speaker, another fourth point, I think, of course, I agree with clause 29. Madam Speaker, you know, the estates, when you go to some of these estates in Nairobi, Madam Speaker, somebody has rented a house for residents. Before you know it, it is a club. People are clubbing there, Madam Speaker. People are doing prayers. People cannot sleep. I'm not saying prayers are bad, but you are living in a residential home. Before you know it, there is Kesha. Madam Speaker, before you know it, there is a club. Madam Speaker, before you know it, especially during COVID, Madam Speaker. So I agree that termination on the reasons of maybe illegal. Even, Madam Speaker, there are estates where even drug trafficking, human trafficking is happening. And I think it is important that to have these powers. And I really want for termination notice. Another one is damage. I think it is important. Madam Speaker, when some of the people who own property, and sometimes you rent your property, kidogo before you know it, Madam Speaker, you go there, you do your routine check. Of course, there is the right of possession to the tenant that is there. You reach there, your property has been destroyed, toilet appliances have been destroyed. What we mean, I think those powers are very important, Madam Speaker, and especially when illegal. I think on the issue of criminal elements, be it drug trafficking or using as a bar in a residential area, I think also it's uncomfortable to that. I think those are additional comments that I wanted to make. The fifth point I wanted to make is that assigning and subletting, I think the biggest victims of this such instances was assignment and subletting, Madam Speaker, is normally municipal houses or county government houses. You find the father was living in that house. The father was living in that house. The grandfather, the father, the son of the son. So some of the properties within municipality, especially within cities, like here in Nairobi, Eldoret, where there used to be municipal houses, you will find there are 5 generations of one family have been living in a public house, Madam Speaker, but they should be the law that guides them, Madam Speaker. And you know, people, even when you go there, they have turned into homes, especially even railways, Madam Speaker. Madam Speaker, I hope it is not within the chamber, because it looks like there are people who are playing twisty. Madam Speaker, what I was making the point is it is important for the houses that are owned by county governments, formerly municipal houses. Municipal houses, Madam Speaker, I hope it will not affect the transcription of the answer to appear that they will, but it's outside the chambers. Madam Speaker, I think what is important is that, and you know, when those people are being removed, you can imagine the police, especially the railway houses, many others, Madam Speaker. So it is always, I don't know how we'll handle this, but it is important. Before you know it, Madam Speaker, they have even extended their houses. People who live in railway houses. You go there is a railway house, but they have started building a Babati. They have relocated all their clan. Before they have want to take forceful possession of such property. Finally, Madam Speaker, on the issue of offenses, I think we need to be specific. Madam Speaker, I think we need to be specific. Saying forfeiting 1 month rent, I think to be punitive enough, Madam Speaker, is that it is important that offenses become specific and become punitive so that it can become deterrent, Madam Speaker. Madam Speaker, the final thing I wanted to make is clause 62. And I hope, I know the argument of National Assembly Majority Leader might say because the Cabinet Secretary is making policy. So they might say National Assembly, but why don't they say Parliament? And I think Majority Leader will need to amend this, that they may notice with the approval, because the issue of ownership of rental houses and many others, Mr. Speaker, sir, I have noted the change on the seat, Mr. Speaker, sir, is that Parliament, and you know most of these issues are managed at the county government's level. Why would the National Assembly having what we call selective amnesia? And they know under Article 93, Parliament is both houses. It is the National Assembly and the Senate. And you know, they want to take us, you know, we went to court because of that simple issues, Majority Leader. Can you handle in Kikao ya wazee with you, National Assembly and the Senate? Because we wouldn't want to be fighting here. And for small issues, we should be fighting for serious issues of lowering food prices in the country and looking at serious issues of National Assembly. But I want to assure that the issue of tenancy, landlords, will be handled very well under the Kenya Kwanza government, Mr. Speaker, because most of the people affected by these issues, Mr. Speaker, are normally the hustlers. And we'll be looking at, and I really want to thank the Majority Leader. This law looks very fair to the hustlers, and it looks very good for the hustler nation, and also all Kenyans, Majority Leader. And finally, Mr. Speaker, is to say this, we should process this law, but I request that the Majority Leader, there are so many gray areas, allow us to put input so that we can fine-tune and improve. And I'm happy the Majority Leader today has been in the House and has listened to us very keenly. I know Ledama Olekina has been busy traversing the country, doing campaigns of Kuzimia, but it is good to see him back in the House, Mr. Speaker, because we still need to work and legislate for the betterment of the country and to look forward.
What's it, Senator Ledama?
Mr. Speaker, is it in order for my good friend, Senator of Nandi, is it Nandi or which county is it from? Which county? Is it Nandi? To impute improper motive that have been traversing the country campaigning for Azimio Kuzimia, when he knows very well that his own team is referred clearly as Kenya Kwisha. Mr. Speaker, you know, this gentleman should restrict himself to debating on issues that relates to the relevance, the landlord and tenancy agreement, but not issues that he does not even have any meat to be able to discuss. This issue, Mr. Speaker, you should find him completely out of order for discussing the issues to do with Kenya Kwisha thinking that he's talking about Azimio la Umoja.
Senator Charagay, strict yourself to the order.
Yes, but Mr. Speaker is making it worse. There was no point of order there. What I just meant is that this law is good. Any presidential candidate should tell the country what they will do, because in this city, the biggest problem when you walk around this city, and it looks like Uzimia, I don't know what is happening, is that most of the people have challenges of tenancy and the issue of property and rentals, Mr. Speaker. So I support with amendments and wish well Senator Ledama. I didn't mean that he has abdicated his duty. I wanted Baba to notice that you are campaigning for him.
Senator Naomi Wako.
Thank you, Mr. Speaker. I stand to support this very important bill from the National Assembly, the bill on landlord and tenants. Mr. Speaker, as I was going through the bill, I realized that this bill can help all the citizens, and as we know, majority of Kenyans, and especially those who live within Nairobi, are tenants. And for the landlords, again, this will guide them so that they can be able to treat their tenants well. So I support this bill because the bill, as you can see, proposes the introduction of price control over the rents based on market values. Previously, Mr. Speaker, the landlords have always been, giving the rents the price they wanted, depending, they could even change within no time and without even giving notice. But this bill then will help the tenants because the rent will be based on market values. That then will help the tenants because nothing will be extraordinary or nothing will be out of order. Mr. Speaker, again, I support this bill because it proposes to repeal the Rent Restriction Act and the landlord and tenants. That again is a good suggestion that makes me support the bill because when doing that, then I know the benefits it has. Mr. Speaker, we know that in the past, the many tenants in Kenya have gone through so many challenges, and especially at this time when people face economical crisis, and even now when we are, preparing for elections, COVID has affected people economically, and many people facing a lot of challenges. Others are trying to relocate even from the city to rural areas. So I know that this bill will be of great benefit to both the landlord and the tenant. Madam Speaker, Mr. Speaker, yeah, Mr. Speaker, if you look at the overview of the bill, it has 65 clauses, and it is divided into 6 parts, which schedules that outlines the terms and conditions that are deemed implied in tenancy agreement. That then means that a lot of seriousness has been given to this. So that many people who may go through this can benefit in different ways. And I support this bill, and especially if you look at the part 2, if you look at part 2 of the bill that establishes the power of the tribunal, you can see that under clause 4.1, it creates the tribunal which is granted jurisdiction throughout the Republic of Kenya. And it means that The commission shall appoint a chairperson of the tribunal, and it explains how that is done. Then that means it will be under good guidance and all shall be put into consideration. Mr. Speaker, part 4 of the bill is the general provision relating to the tenancy, mutual agreement, the normal, and clause 18 to 20 sets limit, conditions, and procedures on the matter in which landlord may increase rent payable by tenants. That means there'll be good control over that, and the bill further issues the manner in which a notice of termination may be undertaken in clause 19. Clause 21 outlines the condition under which the landlord shall decrease rent and services charged to the tenant. Mr. Speaker, if you critically go through this will really favor the tenants and all will benefit, as I said, and I believe when this will be approved and implemented, Kenyans will celebrate this particular bill that concerns the common citizens of Kenya. Thank you, Mr. Speaker, and I support the bill.
Senator Naomi Shionga.
Thank you. Thank you, Mr. Speaker. I stand to support the bill by the landlord and tenant bill brought in this House, a National Assembly bill. Mr. Speaker, sorry. I want to say that this bill has a lot of improvement and amendment that I do support, and the bill which cuts across the agreement of the two parties, especially where the tenant agreement and the leasing or the landlord are parties to discuss the issues that they face in terms of service provided by the landlord to the tenant. I feel like it is very important for us to support this bill. And again, the issue of tribunals. I speak here as one of the people who has been a tenant and also who has been a landlady. And I feel like there are so many challenges that needs agreement, mutual agreement, just other than even the law, but rather governed by the law, especially when it comes to payment. Mr. Speaker, there are so many challenges that come with, especially during, I discovered a lot of challenges during corona pandemic in the past few days that we experienced globally, where most of the tenants were rendered jobless and they were unable to pay their rents. And at the same time, it affected even the landlords or landladies or the owners of the properties who had probably taken mortgages to pay their properties. It affected both of the parties. But again, even with the lifting of some of the precautions or some of the issues that were brought about, or the lifting of the regulations that were put about by COVID, and the people attaining back their status as they used to live, we still have rocky tenants who do not want to feel for the landlord that as the situation resumes, they pay the services or they pay for the services being rendered by the landlord. We still have those who still sit in their houses and claim that the situation still prevails. Mr. Speaker, Kenya is moving on. Kenya has reclaimed its glory and moved on when it comes to COVID. And many people have resumed their jobs. We have changed the way we were living, and the tenants need to respect the landlord, because these properties they are staying in, the landlord or the property owners still are paying the services. So I like the clauses that are been put there, that there's mutual agreement, there is consideration, and there is all that appertain to tribunal that is put across. But again, Mr. Speaker, I just wonder the timing period that has been put, 3 months. probably if you are a landlord and you are given, or you are, the lawyer is stating that you are given 3 months for you to settle or agree on what is to take place. And within those 3 months, we have a landlord who is being surcharged interest on the mortgage that they have taken. What about them? Should the tenant go ahead and, should the landlord or the owner of the property go ahead and stop the courts from increasing, or the banks from increasing the interest rate? Or what, or vice versa? Because if you get a rocky tenant who is not paying the rent, and you are forced to pay you are supposed to pay the mortgage, then you are at loss. You have the property, somebody is staying in your property, but they are not considering you having suffering because you do not have any other. Probably you wanted the rent charges to pay the mortgage. There I find a bit hard, because waiting for 3 months for you, and you are in the same shoe, and you are the one who is paying for the mortgage, it's a big challenge. Let us also consider the time frame that is given, so that we also know that in Kenya here, most of the payments, especially in terms of loans or whatever, they are done they are done monthly. And if the interest continues piling because you are waiting for the tribunal probably to settle your issue, if you do not have any other source of income to replenish, especially when it comes to the property that you took through the loan, then you will suffer. The same, again, when it comes to those rocky landlord or property owners who frustrate, I'm talking from both sides, who frustrate these tenants. Probably the tenant, the jobs were, they had a job and the jobs were terminated because of one reason or another. Some became, probably they are breadwinners, and they do not have now a saving, or they do not have any income. And probably there is that misunderstanding, or the landlord is not understanding. I think this bill will solve so many issues here, but it is always good for Kenyans to think about their Kenyans, for people to think about what is this that is good to the table, that is guided by this framework, that can assist both parties agree to ensure that there is proper understanding and functioning, and even the tribunal needs also to understand that there are people who need to pay for rent. There are people also who need to pay for the loans of the properties. So my problem here is about time frame. A period of a month or 2 months notices and a termination should be reconsidered, other than the 90 days that have been stated here, unless otherwise. Again, it is very important. And I also urge that when the landlords come up with, based on these bills here, or these frameworks that we make, they also come up with, collapse them into a small agreement that is signed by both the leasing and the person, when the leasing of the property is done. It's very important that people realize that those properties are owned by people, and when they are collapsing them into what is called an agreement, they agree on both either side, and any circumstance can forth otherwise, or can change the agreement. But sticking on the law is very important. Otherwise, I support the bill, and I say that it's a bill that will help Kenyans, especially when situations like COVID pandemic comes in place and tries to distract the normal living of not only Kenyans, but people across the world. Thank you, Mr. Speaker, and I support.
Senator Mbogo Chila yako.
Thank you, Mr. Speaker. Mr. Speaker, I want to declare from the onset that I have both interests. I am both a tenant and a landlord. And I can speak from both platforms. I can speak from the platform of a tenant. Historically, I have lived in Nairobi for many years, and I've lived nearly everywhere in Nairobi. I've lived in Dandora, I've lived in Huruma, I have lived in Umoja, I have lived in Kibra, I have lived in a place called Ndumbuini, in Lavington, in Karen, in Runda, in Langata, and I am therefore familiar with the challenges of either being a tenant or a landlord. I also own a few properties in a town and out of a town, and I therefore have the experience of a landlord. Mr. Speaker, the purpose of legislation, specifically this one, is to minimize the friction, the dispute that is prevalent between landlords and tenants. And this is a very key achievement in a society that is developing. Mr. Speaker, we know that ownership of property, particularly where tenancy is required, is an investment many Kenyans aspire to, many people within and without Kenya aspire to, particularly our people in diaspora. So they need stability in this sector. As you sit there, Mr. Speaker, as we talk here, we know that one of the areas of high potential is housing. Government now has a policy called low-cost housing. That will definitely give rise to multiplicity of tenancies. So, Mr. Speaker, it is important and timely that the August House, the Senate and the National Assembly, dubbed Parliament, come with a long-lasting solution to minimize this friction. If you go to court, if you go to the tribunals, you will find that the tribunals are clogged by frequent disputes arising from this relationship. So this piece of legislation, this bill is timely, and I hope when it is fully implemented, we will unclog the judiciary, we will unclog the tribunals with disputes that would have otherwise been unnecessary. Secondly, Mr. Speaker, when there are disputes between tenants and landlords, there is likely to be suffering. The landlord may have borrowed money by way of mortgage to finance that investment. The landlord may have gotten into an arrangement of a financial nature that requires repayment. And if the tenancy-landlord relationship gives birth to a dispute, what is likely to happen is there could be foreclosure, there could be suffering, there could be loss of investment on the part of landlord. And with the loss of investment, there could be loss of family income, there could be loss of stability in families, children may drop out of school, and so on and so forth. On the other hand, when the relationship between the landlord and the tenant goes south, and it's the tenant on the receiving end, there could be loss of shelter, loss of comfort, and loss of many other things. So I want to appreciate those who have brought this bill at the National Assembly, and its proponent led by our majority leader, Senator Pogisho, who we share a lot of history with, including ethnic ancestry of Nilotic nature. So this is one bill that I call upon my colleagues to support unreservedly. Mr. Speaker, you may find that because of the lack of smooth relationship between the two parties, there are other third parties called brokers, others called auctioneers, others called estate agents, and so many intermeddlers, including lawyers, who take advantage of this relationship to encourage and make a living out of the dispute. This unnecessary altercation, unnecessary fights between the two parties is a waste. It is a waste that can be avoided. It is suffering that can be avoided, and I'm happy there is a good attempt that is worthy of our support to address this wastage. There is a good attempt in this piece of legislation to address arbitrariness on the part of landlords to try and squeeze more money from tenants, to try and get more income from people who may be vulnerable without regard to the fact that there is inflation, there is generally challenges and difficulties. So the aspect of this bill that mandates or that decrees that in order to raise rent, there has to be a process, there has to be a form of hearing, a form of engagement, and other considerations is highly welcome. Those of us, as I described myself earlier, who have been tenants all over this city and in other places, know what it means when there is arbitrary increase in rent, know what it is when there is arbitrary eviction. I mentioned that I'm still a tenant. I have an office somewhere in Elgeyo Marakwet Road, and I pay rent. I am happy with my landlord there. During the difficulties of COVID, the landlord became flexible and decreased part of the rent, and after COVID, now we have gotten back to where we were. And a few of the people who I am privileged to call my tenants, we also had similar arrangements. But we cannot run such an important sector on the basis of goodwill of two people. We must understand that inherent in any and every relationship are potentials for dispute, potentials for misunderstanding, and potential for suffering. So this bill is timely, and to the extent that it provides for expeditious resolution of such disputes, to the extent that it provides for steps through which increase in rent is provided, to the extent that it is defining the process of appointment of tribunals to hear such disputes, and that it decrees that rents should be regulated to cushion people of low income from arbitrary hikes in rent, I think the bill is wonderful. Mr. Speaker, I want to applaud members of the Senate who are supportive of this bill. I want to join them and say that this should go on record as an act of patriotism and magnanimity on the part of the Senate insofar as protecting Kenyans of low income if we pass this piece of legislation. With those few remarks, Mr. Speaker, I want to thank you, and I want to thank the majority leader for moving this bill in line with what the law says we should debate it, having come from the National Assembly. Thank you, Mr. Speaker.
Honorable Senators, there being no any other requests, I call upon the mover to reply.
Mr. Speaker, sir, I beg to reply. Mr. Speaker, it is always gratifying when the bill is supported 100%. I would like to thank members, senators who have supported the bill, who have spoken and given their opinion on the bill, but everybody has given it a nod. I want to thank Senator Murkomen, who seconded the bill, the Senator Olekina, who spoke and made a good number of comments on it and wanted some things looked at or relooked. The Honorable Cherargei, the Honorable Naomi Wako, the Honorable Naomi Shionga, and finally the Honorable Chilo Yako, who also has made very strong comments, including giving his own example, which is a very practical way of debating. So I'd like to thank all of them. Mr. Speaker, this bill is, as we said earlier, tries to combine three different legislations into one. and to make it easier for us to deal with the tenant, landlord and tenant issues, which, as has been discussed here, Mr. Speaker, are as old as we can remember. The laws have actually been in existence for such a long time. Even where there are no laws, Mr. Speaker, tribunals come up in the villages and in places where there is no actual tribunal, and there are people who can resolve some of these issues. But this now brings in an official involvement of one tribunal, and the tribunal being the standard. For those who have misgivings, Mr. Speaker, I want to suggest to them that to look at this document again in detail, and also to remember that this document requires that regulations be made. And that is now where the crux is going to be. The issue is going to be in the regulations. So I'd like to recommend that we pass the bill as is, and if possible, then during the moments of subsidiary legislation, we can then have what's required. The reason I say that is if you look at the schedule of the bill, Mr. Speaker, you'll find details on the relationship, on what is the role of the tenant, what's the role of the landlord, and so on. The lessee and the lessor have all been given specific responsibilities. Makes it easier to put together 3 different laws. And so, Mr. Speaker, with those very few remarks, and I want to thank again the members who have contributed, I beg to reply. Thank you. Mr. Speaker, sir, may I also, before final reply, Mr. Speaker, I thought I shouldn't have done that, but I should reply after saying this, the following, Mr. Speaker. Mr. Speaker, sir, pursuant to Standing Order 61.3, I request you to defer putting of the question to a later date. Thank you, Mr. Speaker, and I reply.
Honorable Senators, I therefore defer putting of question to that order until this afternoon. Honorable Senators, order number 121314 stands deferred. Next order.
Order number 15, the County e-Health Bill, Senate Bills number 39 of 2021, second reading.
Senator Judith Pareno. The order stands deferred. Sorry, Honorable Senators, the order stands dropped. Honorable Senators, there being no other business, it's now time to adjourn the House. The Senate therefore stands adjourned until today, Wednesday, 23rd February 2022 at 2:30 p.m.